You're welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. Let's begin by taking a quick trip to the High Court premises to learn what happened on Thursday in the case of the Republic versus William Ato Essien, Tetenete, Fitzgerald Odonko, and Kate Corte Papafio. Of course, she was discharged, acquitted and discharged upon the submission of no case. And so it is the three that are now remaining: William Ato Essien, Tetenete, and Reverend Fitzgerald Odonko. Let's go to the court premises.
The right of the judge to either accept or reject. We're looking at Section 35, even the parties agree, it's subject to satisfaction of the court. And the judge's wisdom has realized that there's a need to look at one or two issues. So you see nothing wrong with the judge trying to assert his authority as a judge in the case.
The judge basically said that this was a bad thing. Couldn't you have got to something better?
Oh, it's a matter of negotiation. And you know, if you're looking at a case involving an accused person, and the person makes a proposal, we also look at the proposal, consider, because let's take it, if you take a matter to court, it doesn't mean automatically you're going to have whatever that you are supposed to have. You need to bargain. We came to 90 million, but they just said if there's a need to up it or do something extra, we have no problem with it, because it's a duty of the judge to scrutinize agreements reached by parties.
So you're now going back to the negotiation team?
We are looking at the ruling. Perhaps we go back or we leave it to the judge to decide.
The judge made a very profound statement that if we'd allowed him to have given his judgment, he would have probably convicted the accused person. He would have gotten whatever he wanted. Why didn't you go through that route?
I think the judge's wisdom decided to adjourn. He made a proposal for the adjournment to the 8th. He later came to the 13th. So it's within his wisdom, because we never prayed for an adjournment. After his ruling, we could have said he was ready to deliver the judgment and we could have taken it like that. But he said we wanted to adjourn for the parties to consider the agreement again. We are not in any way aggrieved by the ruling by the judge. But that's
in all this, since the AG has been stating that he wants to ensure that money that the state owns gets it back. Is this all part of the plan?
Yes, in fact, that's the plan. Because you have instances where people have been convicted involving huge sums of money. They are sentenced, they go to prison, the state does not recover anything, they will lose. So at times, if you are bargaining, if there's a possibility that you can recover something, you need to also take a step. I stated somewhere at the last month that in all this banking crisis, our idea is to prosecute and, if possible, recover. If there's a possibility of recovering, as in the instant case, if the judge agrees with us, then we have to go along that route.
The judge talked about timing, and we know that sometime within the trial, the accused person had indicated that he wanted to refund some amount of money. Why has it taken this long?
It is true. The accused started making the offers to the Attorney General's office long ago, but we were not comfortable or agreeable to the figures that he was proposing. So that's why it took him all this while up to the last point of the prosecution. And we never relented in our effort to prosecute the accused persons. Despite the overtures that the first accused person made to us, we continued to prosecute the case. We got to the end of the case. Then he brought in this last-minute proposal, we thought was quite reasonable, but of course, subject to satisfaction of the court. So the first accused especially, didn't start his negotiation yesterday. He's been coming and then going. But it's rather maybe to his benefit that the last proposal that he made, we accepted.
Should we expect a better deal on the 13th for you?
We are going to look at the figures again. Then we look at the options again. Two things. Either we have a better one or we drop the whole thing for the judge to proceed with the matter, and then we look at where the ask falls.
When you hear the judge in this case, whilst he slammed the prosecution for accepting this, say that it appears the state is compromised, that sounded to me very extraordinary. Do you agree with that view of the way the judge approached it and his pronouncements on this matter?
Oh, on the face of it, it's reasonable. It's reasonable to look at it from that angle, but it's also possible that perhaps the state just, weren't up to the task of negotiating well with Ato Essien. So looking at it, it would appear that Mr. Ato Essien would have to up his offer a lot more, significantly, or like we say in Ghanaian English, gargantuan. he has to make his offer really gargantuan so that the judge will find it very difficult to reject things. And that would help because, as I said, we don't benefit that much from an accused person going to custody, especially or going to jail, especially where there's not a violent offense. It's a white-collar crime. And usually around the world, white-collar crimes, the option to do restitution and to avoid a jail sentence is quite common. You see, we have even also repeated it in the Office of Special Prosecutor Act. So it's in there where people can negotiate. So it's a good thing, okay? It's a good thing. It makes our criminal justice system better, more modern, more rehabilitative, give the person another chance, right? Yes. So it's good.
So the first voice you heard was that of Alfred Chia Yeboah, Deputy Attorney General and Deputy Minister of Justice. He was in the charge, so to speak, in the process in court. And the second voice you heard belongs to Martin Pebo, the Venerable Martin Pebo, the lawyer who is very passionate, and many citizens have come to love him for being blunt speaking and not acting cowardly in the circumstances that we find ourselves. Now, let me introduce our guests for this morning, and we begin with the matter of the Capital Bank and the developments in the court. Alfred Chia Yeboah, Deputy Attorney General and Deputy Minister for Justice, joins us via phone. Kofi Bento, lawyer and Senior Vice President, Imani Africa, joins us via Zoom. Dr. Kwabena Nyako Otu, Chief Economist and Director, Labor Research and Policy Institute, Trades Union Congress, TUC, also joins us via Zoom. And here in the studio with me is Beatrice Annan, member, Legal and Communications Team, member of the National Democratic Congress. Thank you, lady and gentlemen, for joining us on Newsfile this morning.
Thank you, Samson.
Thank you, Samson. Great.
Thank you.
Right. So, Alfred, let's begin with you. People have been very angry at the Attorney General. What you and the accused appear to have agreed on. We don't know the full facts. All we know is that you have allowed the accused to pay 30 million and he's to pay subsequently another 60 million, making 90 million in total, and then invoking Section 35 of the Courts Act. So he will plead guilty and then he'll be convicted, but he doesn't get to go to jail. And it is reported in the media widely that the judge suggested that you guys have been compromised. We'll try and set that record to correct, because that is incorrect for those who have the privilege of knowing exactly what the judge said. So to begin with, many are full of praises for this judge for being the one who is, as it were, keeping the gate and watching the public purse. And you, that is supposed to lead this for us, are disappointing us. So for starters, what do you have to say?
Thank you very much, Samson. As a start, I would like to place it on record that the Attorney General's office, and for that matter, the Ministry of Justice, has never been compromised in this matter, will never be compromised in this matter, and is not prepared to be compromised in any other way. That thing should be set straight. This particular matter, as we all know, has been pending in court since 2019. The accused persons originally were 4. At the close of the defense case, the 4th accused person was acquitted and discharged by the court upon the submission of no case. So we are now left with 3. Out of the 3, Mr. Mr. Ato Essien, who happens to be the first accused person, has been charged with 3 main offenses: conspiracy to steal, stealing, and money laundering. The second accused person has also been charged with conspiracy with Ato Essien, as well as stealing substantive offenses. The third accused person with abetment of crime. The total amount involved in the whole case is 192 million Ghana cedis. 192. In the course of investigations, it came out that an amount of about 100 million cedis had actually gone back to Capital Bank. So that amount, from our point of view, is still with Capital Bank, leaving 92 million. Then in the course of investigation, once again, the first accused person made a refund to Iyoko for 1.34 million Ghana cedis. So if you net everything, the amount left is about 90 million plus, 90 million Ghana cedis. Let's also not forget that for all the negotiations we've had with Mr. Ato Essien, it didn't start last week. 2021, his lawyers, relying on Section 35, made an offer to the Republic. And they indicated in their letters to us that Ato Essien admits only 27.5 million Ghana as the amount of money that he thinks it could be made to refund. 27 million Ghana cedis. We met and said, no, we disagree with you. We had a series of letters to that effect. And at the last time that we even had, because they still insisted, they moved forward and said, let us go to 57.5 million Ghana cedis, and said that was the only thing that he concedes or agrees that he needs to refund. We rejected it. Then he later on went on to add that he was prepared to top it up by way of compensation to make it 70 million Ghana cedis. That one too rejected it. Then the last offer they made was that, fine, since we were insisting on rejecting whatever until we got to the 90 million, they said, fine, we're going to pay the 90 million. They said, fine, if you've gotten that way, after all, under Section 35, it is permissible. But the moment the state agrees with an accused person, it's not final. The judge who is sitting on the matter has the power under Section 35 to either reject, modify, or endorse it. So we were clear in our mind that our agreement with the first accused person wasn't final. It was subject to the satisfaction of the judge. And Section 35, I've heard this argument that it's not applicable. Don't respect. The very judge who is sitting on the matter has stated in court many times that he, as a judge, since Section 35 is available to the accused person anytime that accused person, first accused person, was ready, he could be informed as the judge, even at the last minute. So we also labored under that impression. But if the accused person was ready to come up with that sum, then perhaps we also need to look at it. In any event, Samson, you know how the litigation goes. If you take your matter to court as a prosecutor, or even in civil matters, you can never determine the outcome of such a case. So that's why even have, at the point in time, you need to negotiate. It's possible even go your way, it may also not go your way. In negotiations or in bargaining, you need to look at how you can go, where you can go, and the point that you can go. So in our wisdom, that small wisdom that we had, realize that, fine, it will be in the interest of the state to get money from an accused person, rather than saying that an accused person should go to jail and we don't recover anything. I can cite various instances in this country where people in high places have been convicted, sentenced to prison terms, and the state could not recover even 1 Ghana cedi. So insofar as we have the Cost Act that was enacted in 1993, way back with the amendment, and in the wisdom of Parliament, they've made a provision for that kind of opportunity to be available to an accused. As prosecutors, we were not ready to also just close our eyes to such a provision. So that's how come we got to where we are today.
Okay.
But whatever we've done is subject to the satisfaction of the judge, which we still think he has the power to either amend or reject.
Okay. We'll get to why your preoccupation, as you say, or your primary interest is in recovery of money rather than wanting someone to be jailed. That is, if you succeed in getting them jailed and not getting any money from it. And you say there have been many cases. Of course, Ghanaians are aware of the very, very many cases, including, of course, the JoyNews matter, which you still are struggling and can't get even a quarter of that money back to the state. We are aware of the judgment of this same court on the 12th day of May 2020 in respect of the Republic versus Eugene Bafuboni, Matthew William Tevi, Dr. Owusu Esau, Alhaji Salifu, Mimina Osman, and George Derek Opong, in which, in the end, 3 of them were convicted. I think 6 years. One was for 5 years or so. In respect of the NCA matter, in excess of $4 million US. As we know, you guys have not reported to us that you have recovered any money. Whilst that is important, that we appreciate that you want to take money for the state, the judge made a statement that your conduct smacks of or seeks to be something that will make crime attractive to people. Doesn't that suggest to you that it appears that you were making success from the judge's comments, that you would have gotten jail terms for the people involved, you would have been successful? So maybe there's no need to be rushing to want to settle matters. And the bottom line for the judge was that you are seeking to encourage or make crime attractive.
Yes, Samson. The judge spoke from an advantage position. He's the one presiding, and he knows what he may want to do. But as prosecutors, we cannot be certain that we will win our case. That one, we may go to court. It may go the other way. But perhaps the judge passed that on because he's sitting in a privileged position. So that's the response I'll give to that. But in any event...
Mr. Shuaibua, you cannot be certain that you will win your case. But at the Attorney Generals, as prosecutors, as we know from some prosecutors, unless they are sure of about, say, 80% success, they don't go to court. So you must have some conviction that you have a good case. That's why you go to court. Is that not?
Yes, we have a very good case. That's why we are in court. That's why we call 17 witnesses. But at the end of the day, this is the duty of the judge to either uphold whatever we presented or dismiss it. So far as we cannot deliver judgment in that matter, we cannot be certain some of us to deliver judgment. We have done our part. Now this business or this issue about making crime attractive or something, if someone is convicted for stealing, money laundering, you know the legal effects, you know the implications, you know the limitations placed on such people, because those offenses border on dishonesty. And if you take our constitution, there are clear provisions on how people have this kind of limitations because of their conviction on offenses involving dishonesty. If we move further, if you take the Companies Act, there are elaborate provisions on limitations placed on people who have been convicted for offenses involving dishonesty. You take the Act 930, the banks and financial specialized institutions, you have provisions there. So apart from the person going to prison, which is something that is also not ruled out, there are other serious limitations on people who are convicted.
Educate my audience a bit. What are these limitations you are talking about because of a conviction? And in which matter, what you are saying essentially is that using Section 35 of the Courts Act to settle the case doesn't mean that there will not be a conviction. There will be a conviction, and therefore, Mr. William Ato Essien will still suffer the consequences of a conviction. What are these consequences that you are talking about?
Yes, Samson. First one, let's go to our Constitution. if you want to hold any public office, if you want to be an MP, if you want to be a minister, a deputy minister, if you have been convicted of an offense involving dishonesty, you are limited from holding such positions. Now, even if you want to be a chief, if you're a lawyer and you want to be a chief and be convicted for an offense bordering on dishonesty, you cannot.
In fact, you can't be a lawyer. If you're a lawyer, you lose your license.
That is it. If you're a business person like Ato Essien, who is into finances, from the Banks and Specialized Deposit-Taking Institutions Act at 930, you cannot be a director of any financial institution or work in any position relating to finances of a company. You cannot. You are bad. If you go to a Companies Act, you cannot be a director. And so these limitations are there that if you think that you've been convicted, oh, it's stealing, so you're going to sleep, you've paid, and that is it. I tell you, even if you are traveling out of state and you have a conviction of more law, a very serious offense, I tell you, there's a place that you go and nobody will even be ready to listen to you or even deal with you.
All right.
So there are serious limitations.
Right. We'll get to the details as to the figures because the public is aware that the Bank of Ghana gave liquidity support of 620 million. People want to appreciate exactly why we have come to. Is that not that amount for which you are prosecuting these people, and why is 90 million sufficient? You have attempted to explain, but we'll go into details about that. What the public is also asking is, you can have the two. You can have the person convicted, sent to jail, and still get your money back. So you can have, all that. Why are you not interested in that? If the person is going to be convicted for stealing, by our law, and per that particular section that you are charging the person on, section 124, it will not be, a maximum of 10 years. It will rather be for 25 years, correct?
Yes.
Right. And then for money laundering, according to the law, you are supposed to be liable to a fine not less than 100% and not more than 500% of the proceeds of money laundering in the case of an individual. And then a term of imprisonment of not less than 12 months and not more than 10 years. Both the fine and the term of imprisonment, or a fine of not less than 300% of the proceeds of money laundering in the case of a corporate entity. So the public is saying you can have both. You can get your money and send the people to jail at the same time. Why do you want to take the money, give them a conviction, they suffer all the limitations you talk about, and then they don't go to jail?
Samson, it is true that you can get a conviction and also have some recoveries. But that too depend on whether the accused person has property that you can fall on. Usually I don't like citing matters, but since there's a public, the Wyoming matter, 2011 to date, how much has the state been able to recover in that particular matter?
Of the 51 million?
Exactly. You want to trace and get properties of people that you may want to have so that you can go through the legal process, auction and get money, and you are not getting it. So the possibility
how much did he pay? How much did he pay himself? I think some 4 million. And then, later you got some properties at this popular place, and Trasaco, and those properties, yes, they don't give you so much to cover the 51 million.
Not even up to 20%.
Not 20%.
Yes, not even up to 20 or 30% if my figures are right. And so that money is outstanding because, and per our laws, if someone doesn't have the asset that you can fall on, you cannot say you're going to prison the person. So in this particular matter, maybe they are convicted by the court, which we are certain the court may do, since we have a very good case. That is how I may want to state it. If they are convicted and Ato Essien is imprisoned, and the court says we should go and then go get his property and then auction. So that's the next hurdle. Do we know his property? Properties does he have? And if you identify, will someone not come in and say, oh, this property is mine? And how long will it even take us to go through that process? So that process, if you have the property there, that will be the thing that, as a prosecutor, we may want to follow. But if you don't have it there and then you go along that line, the person will go to prison, the money. And some people may also, I'm not saying that this instant case, they may still acquire property in the names of others.
That failure or difficulty, don't you take part of the blame? Because since 2015, any wise person who knows that he's a candidate for trial over this bank collapse issues, 2015, 2016, until 2017 that you put him before court or so, I think it will be such a lousy lawyer or a lawyer who doesn't know what he's doing that will not advise the client to do the right things. May not even be a lawyer. It will take the person himself deciding to conceal his properties, put properties in the names of other people, among others, so that you can find them if eventually he's convicted. So are you not partly to blame for not ensuring that at the beginning you were proactive enough to take control of these properties?
The matter was investigated by Iyoko. And Iyoko, through the investigations, did what was expected of them. As I speak now, I don't have any to the fact that property A, B, or C belongs to Ato Essien, unless, of course, I fall on Iyoko. But what I can say is that if we go by the suggestion of the public or some of the members of the public, that we go for conviction and recovery, we have no problem. But the issue is whether we can get some property and then get the money for the state.
He had, we understood, he had about 19 new vehicles that he was taking charge of from the port, that had arrived at the port. You confiscated them. It's the same way you must find his properties so that he goes to jail and suffers, his properties also suffer. Is that not what you should be doing?
Samson, that is what is the ideal situation which we'll be happy to do. If we know the property, if the public can come out, perhaps we know A, B, C, D, and we can praise. We will even drop this kind of plea again. Sorry, we will even drop this issue about going under 35. We may say, fine, we are not bothered. Let's go to the trial. When we get judgment and the court orders, we'll take it.
Okay. Now to this issue about the figures. Yes, about the figures. You have informed us, and for those journalists who have followed this story, they have known that this is not the first time. So it is not exactly a surprise on the court that he sought to come under Section 35. And that this has been the manner in which he has sought to proceed. And I have some of the records of the court here. From the 21st of May, 2020, before the court actually granted you the permission to try to use Section 35 to see if you can settle the case. And then on the 18th day of June, 2020, the court again granted further permission. On the 18th of June, the court said, I accede to the prayer of both the prosecution and defense counsel for one last adjournment to enable them conclude the negotiations under Section 35 of the Courts Act, Act 459. I place on record that, notwithstanding any possible outcome of the negotiations, trial will proceed on the next adjourned date, adjourned to 9th July 2020 at 11 a.m. Then subsequently, on the 4th day of November 2021, on the record of the court, there is also the court saying, and I quote, by court, I have listened to the learned chief state attorney and have attended to the submissions and prayer of learned counsel for first accused, that's William Ato Essien. I have noted the attempt underway by the first accused to take advantage of Section 35 of the Courts Act, 1993, Act 459. I have noted in particular the prayer for first accused to be afforded more time to conclude negotiations and a further date for him to open his defense. The court has not hesitation at all in granting the prayer for more time for the parties to continue their negotiation, but the court is unable to accede to the prayer to defer the opening of the defense of the first accused for a number of reasons, and the court gave those reasons. So at least for 3 times, the court was aware that there were attempts to settle from May 2020 up till November 2021. But don't you think the court is still justified that on the day that it is going to deliver its judgment, you guys spring a surprise on the court that it should use this process rather than give its judgment?
The court was right in the sentiment that it expressed with regard to the timing. But we need to let the court know where we got into. That's why in all these transactions, it is not final. It is subject to the satisfaction of the judge or the court. So if the court, in its opinion, it thinks that, fine, this matter is not a matter that will go unaccepted because of time, we have no problem with it, because we cannot impose our agreement on the court. But people who are patronized services of the court and who are also partakers in the law of justice, we must not hide information from the court. We need to let the court know this is where we got into and whether the court agrees or disagrees. So the timing is something that the court may want to say because of where we got into it, they want to deliver a judgment. We will not have any problem at all, because we have called 17 witnesses. They have closed their defense. It's left to the judge to deliver his judgment.
But like a plea bargaining process, you are entitled to come to this kind of conclusion any time before judgment. Is that not so?
Exactly, Samson.
So,
and that's why that was what was done in this particular case, before judgment. After judgment, you cannot do it. Before judgment, it can be done.
So what do you make of the court's surprise attitude, and also the court's suggestion that what you are trying to do is actually Section 35 doesn't afford you a settlement in this regard because the loss, so to speak, is not economic loss to the state?
We disagree with the judge on his interpretation of Section 35 with regard to the facts in this particular matter. Now, the money we're talking about, the 192, belongs to Capital Bank. We agree. Where is Capital Bank now? This Samson will help me. Is Capital Bank still in existence? No. The assets of Capital Bank have been taken over by the government via Bank of Ghana. So if I'm talking about who owns the property of Capital Bank, it is the bank, it is the government of Ghana. So that loss that we are talking about, the ultimate sufferer is the bank, is the government of Ghana. So we disagree that the money does not belong to the government of Ghana, but rather the shareholders of Capital Bank, because Capital Bank is no longer in existence.
I have followed this case and with great interest, of course, also because, and I'll make this disclosure, I'm just moderating. The disclosure is that, for those who don't know, it's already public that my firm are lawyers for William Ato Essien in the civil case, not the criminal case. We are not in there. That's Stadio Sorry and his firm. Now, the question I'm asking you now has to do with in the submission of no case. In fact, when I think Dominic Ayene, K.T. Hammond, and others appeared before the court, I think their first comments to the court was that, how can I steal my own property? And in the submission of no case, they make that point, and the judge rejected it that the money belongs to them. It doesn't belong to them, it belongs to the state instead. So how do you reconcile that now that the judge suggests that the money is not the state money, but it belongs to the shareholders? Does it appear that the defense is being armed against the state?
And that's the reason why we disagree with the judge on that. The money we are talking about now belongs to the state. In any event, if you talk about someone being the owner and cannot steal his own property, as well as stated, that one, any court will reject it. Because if you talk about company, you may be 100% shareholder. But if you take money from that company without the consent of the board of directors, you've stolen the money.
Okay.
Even though you're 100% shareholder.
My last question to you before I go to my other guest and come to you finally as to your next line of action on the 13th of December is, what are you in court prosecuting Ato Essien and the others for? How much money is at stake? Is it not?
Yes.
Is it not 620 million Ghana cedis being the liquidity support that was given to the bank that led to this suit?
We are in court prosecuting Ato Essien and others with respect to an amount that the Bank of Ghana gave to Capital Bank as liquidity support. And that amount was 620 million. Out of that amount, 192 million Ghana cedis, from our point of view, was stolen by the accused person, the first accused person. So the amount the Bank of Ghana gave them was 620. The real amount is with Capital Bank, for that matter, with the government, because we are now running that bank as a civil entity and another institution. What is now in contention is the 192 million Ghana cedis, but not the 620. But the 620 went, but only 192 was taken by the first accused and the others without a consent.
So how do you accept 90 million? And the judge was very angry about that. How do you accept 90 million as a refund for 122 million?
It's not 122 million.
92 million, yeah.
The 192, as I said, 65 million cedis. As a fact, we realized that after the auditing, that money was with Capital Bank because there was a company that sought to buy shares in Capital Bank with 65 million Ghana cedis. That company, we realized that that company also belonged to the same Ato Essien. So Capital Bank took that money and said, we're not going to give you any shares. So that money is with Capital Bank. There was another 35 million Ghana cedis to also acquire shares through a company. We lifted and realized that that company was also owned by the first accused. We said, fine, that one too, this money you paid, so you're not going to get any shares. So 100 million out of 192 just came. Thereafter, through investigations at the local, Ato Essien also refunded 1.3 million Ghana cedis. So the amount is not 192 now, it's at 90 plus.
You said 65 million. 65
yes,
can now be traced as money that is still within the state.
Yes.
Then 35 million also can be traced in the same manner.
Exactly.
But he paid 1.3 million.
Yes.
That gives us a total of how much?
I think that's about 101 plus, so 101 plus, but if you add it, you've got 100 million to this plus 1.3, so about 101.3, yes.
Okay.
Yes.
Okay. So as far as you are concerned, how much is the amount left?
The amount left now, after the payment, is 90 plus million Ghana cedis.
90
that's
plus.
The amount. Yes, that's the amount left.
So the judge is...
We are still charging, or we charge him with the 100 million, that the amount that he refunded, because he stole it before returning it. So that will not absolve him.
Okay.
Yes.
So the judge is still justified that in 2015, 2016, you don't come to 2020 to seek to refund that amount without interest and without some compensation to the state.
The judge may be right in his conclusion on that. But the question, as I indicated earlier on, Ato Essien has never admitted stealing 90 million Ghana cedis. He has always maintained 27.5 million Ghana cedis.
Okay.
The later moved to 50.7. So from their point of view, they have never stolen 90. But they decided that they were going to pay something to top it up to 70 million. We rejected it. Then later they said we will have to go to 90. I said, fine, getting to 90 is quite reasonable from our view. So let's accept it and see whether the court will also satisfy with it.
Right. So eventually, what the accused admits is 27.5 million.
Yes.
Which is what he calls the promotion.
Promotion, yes.
The money that he felt that he was entitled.
Yes.
So he says, this is all I owe. So first, that is what he sought to pay to the state, and you rejected his offer of settlement.
Exactly.
And then later, they managed to push it up to 57. And you rejected that too.
Exactly.
And now they have pushed it up to 90, and you feel that is good.
Yes, Samson.
Okay. Let's hold it on there, and then we'll return to you finally. But the issue of compromise. You were sitting in the court. I came in there. By the time I got there, everything was almost done. He was rounding up. Did he say that the Attorney General was compromised in this matter?
I never heard a judge use the word compromise. No. I don't think the judge would have even said so. No. In terms of he saying that we were compromised. Maybe,
I think he used the word compromise, but not to you, the Attorney General. That what you were doing would compromise the consequence for the other two.
Exactly. With respect to the other two accused persons, A2 and A3. So remember, A1 has been charged with conspiracy that he conspired with Ato Essien. So if Ato Essien is pleading guilty to a charge of conspiracy, what happens to that person? Because conspiracy is to be two or more.
All right.
And you can't agree with yourself. You must agree with someone. So is it the fact that he agreed with the second accused person automatically? I think that's the question that was being raised. But in any case, as a legal principle, if you plead guilty to a charge, it's not binding on the other accused person. That is it. And then there's an aspect of abatement, that someone abated Ato Essien, the third accused person. So in the case like the Ato Essien pleads guilty, does it mean that the accused person also abated him? These are legal issues that will have to be unraveled in the judge's judgment.
Okay.
With respect to A2, A3, if we agree under Section 35. So the word compromise, as to whether AG's office has been compromised. Some of us are in public office to serve our nation, to stick to the rules that we are supposed to follow, and we are not prepared.
All right.
If you point guns at us to compromise our position.
But don't you take the concern of the judge that if you settle with the first accused, who is facing the substantive, charges of stealing, money laundering, and all of that, if you take that and the rest of them are merely, quote unquote, I say merely, the consequence is heavy. Because even if you are an abettor, you will suffer the ultimate sanction. So if, you are settling with the first accused and the second and third only have charges that are supposed to be just that they abetted the process, aided and abetted the process, don't you see that you are compromising their situation? Is that not a concern that you should take note of? So that the main person will not go to jail, but the other persons who were just aiding and abetting, so to speak, I say just again, if they are found guilty, they go to jail.
Now, Samson, if you look at the charge sheet, the other two accused persons, A2 and A3, especially A2, apart from conspiracy, is also being charged with stealing. So if the 90 million we're talking about, part of it, A2 has been charged with it, with stealing. It's only the third accused person who has been charged with abatement.
That's Fitzgerald. Is it Fitzgerald Odonko?
Yes.
Okay.
That's well stated. If you are convicted for abatement, you may be punished as if you were the very person who committed that offense.
That's right.
So if the first accused thinks that fine, I'm guilty, and because I don't want to go to jail, I want to take advantage of this, and he doesn't go to jail, and you think that you are not guilty, but the court comes to a conclusion that you are guilty.
In fact, by our law, even if the offense was not completed, you will still suffer as an abettor, right?
Exactly.
As a conspirator.
Yes, but you cannot force an accused person to take advantage of Section 35 because he believes in his case.
Okay.
That's the reason why A1 has been coming. I mean, if I will deal with you, but A2 and A3,
all right,
we don't have to worry them at all.
Okay, thank you very much. Please hold on. Let me go around and get to my other guests. Then I wanted the Attorney General themselves, who are, in the center of all of this, to try and help us in a better way before every other person will come in. I just hope I succeeded in doing a bit of that to assist my other guests. But we have also seen documentation that suggests that the Attorney General, the first accused, William Ato Essien, for all the time was admitting to only 27.5 million as money that he was ready to give back, because that was related to business promotion payments to him. And that takes care of counts 13 to 23. Remember, the counts end at 23. And then there was the other two from counts 1 to 13. So he seems to cover everything. Then the Attorney General has been objecting to this completely. So eventually, what he has actually admitted to is 57.5 million that he agrees to pay. So by his letters we are seeing from his lawyers, it does appear that the Attorney General rather may have done a good job by getting up to 90 million, but not exactly that. It is 90 million that is in fact owed, and they are paying 90 million without interest and without reparation or restitution. Because the record also, according to the lawyers for the accused person, show clearly that what in fact is owed is that amount, nothing more. So if they are paying 90 million, it is not a fact that they are admitting to owing 90 million. Now, let me go to Kofi Bento. Kofi, thank you very much for joining us. I don't know where you take it from.
Well, Samson, good morning and thank you. It's interesting, but it's also very serious. I take it really from the judge's pronouncements. And as a lawyer, you and I know that a judge must be so restrained that you cannot read his mind except through his judgments. And difficult as it is, that is what they are trained to do. And I have to say, most of our judges really do well at that. You think you're winning, you lose. You think you're losing, you win. Even when they are reading the judgment, you can't tell exactly where they are leaning. So it's interesting that we heard so much from this judge at this stage. And let's be clear, again, you and I are lawyers, this matter is still with the courts. So we are not debating the merits of it. We are just looking at the general issues.
We are discussing the outcome of Thursday.
Yes, but I'm saying it's still in the court. So I just want to let the public know that we are not prejudging the matter.
Exactly.
And we are being careful not to go into the merits of it, just to set that aside. Now, let's be also clear. The judge was right and within his powers to accept or reject the deal that the AG made, and was right, okay, to give, some sort of, reason for it. But I do think that in making the statements that he made, he opened too many doors. He opened too many doors. First, we need to know that Section 35, which is what the AG was relying on, it was started in the judge's courts. Those of us who know about this case know that he basically opened the door and said, you can look at that. And let's make this caveat also. People are emotional about this matter, and they know nothing about the details. Nothing. Some of us have taken time to go into the details. It's a bad case, but please, if you don't know too much about the details, hold your peace. I'm saying this because it is the lawyers in court before the judge who will go through the numbers. Samson, I know you have some numbers. I also have some numbers.
Yes.
What is Ato Essien admitting to? How much has been missing? How much has been recovered? What is left? And all those things. So the details people can't understand, and we should all reserve passing comment on this or that. So back to the issue. Look, as it were, the AG went in squarely within the law to try and gain something for the state. Now, we need to know, I have seen people who were willing to go to jail, come back, and come and enjoy their money. I don't want to tell you a story about somebody who kept us 2 hours in the Forex Bureau after they had come from church changing money. So there is good merit to this Article 35, Section 35, and I think that I trust the Aegis Department. So it was sad to, hear suggestions that somebody has been compromised or whatever it is. Let's, leave that. And let's leave them to do the work in court. And then let me make this point also that, look, I feel a bit worried about the approach in terms of the statements made, because I think it revealed too much of the judge's emotion and where he was going. And to everything that was said, I think there are sufficient legal and jurisprudential arguments against those positions, which I believe Mr. Essien's lawyers are well capable of and they can make. So I'm making general statements to the effect that many people are emotional about this matter. This is one of the matters where I would trust the AG and the people there, some of who I know and I trust, to do a good job. And until we get all the details, we should be restrained. And for whatever is worth also, I think that nobody should really be taking certain stances publicly, as it were. Let's let this process run its course. But as far as I am concerned, I think it is proper that we give place to Section 35. Too many people have stolen money from this state and have been willing to go to jail for 5 years, come back and enjoy it. If we can get something back, and you know the litany of cases, we don't have time, so I don't want to go into them, where people go free and nothing happens. And even cases, you just cited some, Woyome, the Dugu cases, and we don't recover anything. So for me, if there is a chance to recover some money, and like you said, you can actually recover money and also convict the person, and the person can actually also go to jail. So we should not get this view that somebody is going to cut a deal to let somebody, run free, and that this is a bad situation. It is not. The details are what are in court, and they will have a chance to also make those arguments again before the judge. So for whatever it's worth, I think all of us, including my lord, the judge, let's see how this pans out ultimately. But people must know clearly that 35 is in the law.
Yeah, so Kofi, you and I are privy to some bit of the documentation. Now, in court, it is, as it were, shown without any question that there was a repayment through an EcoBank check with a specific date of 65 million. There was another repayment via EcoBank check, that's the tranche 2 payment of 35 million. And then the money that Essien paid to Iyoko also is not in doubt, 1.3 million. And then there is a 30 million amount that is supposed to be held by the receivers for the sovereign bank. You remember the money that was, out of the liquidity fund that was used to set up another bank. Yeah. So as far as, the first accused is concerned, what they in fact owe, actually, is 26.2 million. Attorney General may have done a good job by getting up to 90 million, rejecting just paying the 27, which was 26 million, rejecting 57 million, and eventually getting 90 million. But Kofi, the judge is concerned. Many Ghanaians are concerned. You don't have to make crime attractive. That you take money, you refund it, you don't go to jail. You may have even made profit out of it.
Samson, I agree with you. But again, like I'm saying, there are many arguments against the sentiment that has been thrown out. One of the arguments is in the numbers. And those of us who have seen the numbers, know that indeed the deal that has been struck by the AG may be a very good deal. But again, I don't want to go into the merits of the matter, partly because it is sub judice. Number two, there is so much emotion around this matter that anything you say that sounds like it's going to be in somebody's favor will make somebody think you have been compromised or I have been compromised. And so we should leave them to do the numbers in court, okay? What we must know is that there is very good reason in philosophy, in jurisprudence, in what is proper and practical for us to have a Section 35. And I repeat, because there are people who actually still stake money and want to go to jail for 5, even 10 years, come back and enjoy it.
In that regard, you are disagreeing. In that regard, you are disagreeing. You are disagreeing with the judge that 35 is not applicable in this matter.
Again, I have many arguments on that. I don't want to make those arguments here. Let me just say, yes, I disagree with him. Because 35 is a very good provision, and those of us who are in policy, who look at what goes on in this country and the millions that we lose and we don't recover, you see, over the decades, over the years, people have come to realize that, indeed, without 35, it is lucrative rather to steal. So, indeed, the argument is counterproductive, you know, against what was said.
Okay.
That, oh, because of 35, people are going to steal. It is without 35 that people steal. And we've seen some, I've seen some. I don't want to go into the details. The point here is that with 35, you know that if you steal, you can be asked to cough up the money. And in this particular case, if you go through the numbers, what is being coughed up is quite substantial given what is being admitted. Okay? And so going to jail will not let you off to go and enjoy the loot. But again, I'm so restrained.
The judge's argument here is that the money belongs to the shareholders. It doesn't belong to the state. Even though we have heard the lawyers from the start argue that liquidity support is in fact loan, and that loan is payable, so it's not state money, so to speak. What do you make of how the judge wants to look at it now? It doesn't matter that from the onset the judge was amenable to them using Section 35, but where it has gotten to, he's entitled to have a change of mind, and he is a final approval of what is agreed.
Samson, you are leading me into temptation. There are very sound arguments against that proposition. I will restrain myself and simply say this. If the state has gone through a process of cleaning up the financial sector and cost us money as taxpayers, the money that can be recovered can be argued to be money for the state. But again, I don't want to go into the merits of the matter. I believe the lawyers involved are very competent. So what we all should say, we should stay on the policy issues that the judge is right to voice those concerns. In fact, that is what the average person has in mind. But judges, lawyers who have details and also have the benefit of understanding the law must actually help the public and move us more from the emotion into the facts by restraining ourselves and dealing with the details in court. Now, after the judgments have been given, we can take our time to explain why this happened the way it happened.
Well, judgment giving. Judgment presently is being arrested, so to speak, in respect of the first accused.
Well, I still want to respect the fact that it is not over.
Okay.
But I just want to say, for whatever is worth to the public, that this is one of the cases where I think our state officials are doing a good job.
Okay, thank you.
Look, over 10 witnesses were called. The detail we are going through, you can't just get up and then, throw somebody in jail because you believe he has done this or that. And then when you go into the facts of this matter, there are people who other people think should have been also, prosecuted. No. If you know the facts, you know that no. Yeah. So let's sometimes you have to trust the people who we have elected to do the job. And in this matter, really, I will say that I trust what the Aegis department is doing. Okay,
thank you very much. And Kofi says people also believe that there are people who ought to be standing trial who are not standing trial. And top on that list that has always come up has been the chairman at the time of the Capital Bank, that is Dr. Mensah Otabil. What people forget, and that's the aspect that my firm is involved in, is that there is a civil matter also pending. And Otabil and associates, ICGC, is it Otabil himself, are all in the civil matter to recover specific amounts that the state, the receiver, deems they to be owing and they ought to pay. So that one too is going on there. That one actually has about 18 different defendants, including Ato Essien, who is the first defendant. Yes, Beatrice Annan.
Thank you very much,
Right.
Samson. I've listened to the discussion and I've listened to the Deputy Attorney General, but on this matter is the duplicity and the complicity of the Office of the Attorney General that I want to talk about. And listening even to him more, for me, I think more investigations should be undertaken. Why do I say this? I believe that the prosecution of Ato Essien A1 and the others in the instant manner is just a face-saving gimmick to rationalize why the government had to use 25 billion to clean up a sector that we are told needed 9 billion to clean up. And so, some way, somehow, signals have to be sent to the people that we are not wrong, albeit I believe that they are. Why do I say this? If the government believed that these persons have indeed caused them to use in excess of 25 billion to clean a sector, what would the recovery of a 90 million out of it do? Now, the question is that I have heard you
That's
say...
a total of how many banks? This is just one of the
Yes,
banks.
that's a total of... So I will be doing the average.
Okay.
Now, I've heard you say that in that case, the first accused only admitted to about 57.5 million. Now, listening to the Deputy Attorney General, I'm even more worried because in his submission, or the case of the prosecution is that 620 million were advanced to Capital Bank by way of liquidity support, out of which 192 is
what they are pursuing.
He does not tell us why the 90 million. He tells us that some way, somehow, 65 million cedis were found to be within or still with the state. And he made a statement, I hope it's a slip, that 35 million belonged to a company where the first accused is a shareholder. I hope that statement was a slip. Because if these are the facts, and the Attorney General's own admission is that 90.66 million is what is outstanding, then the question then becomes, what was the basis for the state accepting the 90 million? Because I have been an advocate of non-custodial sentence. I have written copiously on non-custodial sentence. But we have to know why the Attorney General is settling for 90 million when in his own admission, given the figures, it is 90.66 million that is in contention.
Okay, let me read a portion of what is supposed to be confidential that we have been privy to, which Kofi Bentil was referring to, which ended up in the settlement. They actually brought in accountants to do whatever reconciliations had to be done against the investigation that had been done to bring up the amount to 192 million. And this is what the lawyers for Ato Essien contended. And I believe eventually what the AG admits. It says the sums of 65 million and 35 million are the subject of counts 1 to 4, 9 to 11, preferred against Mr. Essien. In respect of the aforesaid sums, 35 million and 65 million, our client has testified and proved that the aforesaid sums of money remained in the balance sheets of the capital banks as deposits against shares until the receiver was appointed. So I refer to you 2 checks paid to through EcoBank,
yes,
where these monies sit there.
Yes.
It says, with regards to the 35 million in particular, we must add that the aforesaid sum forms part of the 100 million, which are the subjects of count 1 to 4, with the effect that making the same sum 35 million, the subject of counts 9 to 11, also carries with it the danger of double jeopardy. I suppose you will understand this.
So, yes,
and then they say, in any event, payment of the 35 million is evidenced by Capital Africa Group check dated 27 January 2019, and they bring the number. Then the payment of the 65 million, they also give the check number and the date of 1st of February 2016 payments.
So by this, it means that the Attorney General has admitted that.
He said so.
Yes, that it was 57.5 million. That are the monies appropriated or allegedly misappropriated. That is it. So that brings me to my point that if you have 8 banks collapsed on the basis of some misappropriation, theft, and other corporate governance issues going on, and you said that you were cleaning it. Now we are now being told that the Attorney General's own admission says that the 65 and 35 can be found on the balance sheet. So
and then there was a 1.3 paid to Iyoko.
1.3 paid to Iyoko. So back and forth.
And then Iyoko has also seized 19
So
vehicles.
back and forth, the admitted figure is 57.5 million. My point, and I will not also talk about the case because I know judgment has not been given. As a lawyer, I'll refrain from going into the merits. My case is that looking at the banks which were collapsed, if in the case of Capital Bank, we are being told that it's 57.5 million. If you run the average, how much are we talking about? For which reason government was clothed with capacity to spend 25 billion cedis in trying to get these sectors back.
Okay.
That's
but
my
you also
main
appreciate
concern.
what the Attorney General speaks about, which I think Kofi had mentioned, about the fact that the state has taken over these entities.
Exactly.
Now, when he took them over, Capital Bank and UT Bank were handed to GCB Bank.
Yes.
So their assets, everything,
yes,
remains with the state.
Yes.
You appreciate
yes.
that?
And
so that is money.
So that's something I think you should get the point I'm making. The point I'm making is that...
No, your point of duplicity and complicity is what I need to appreciate.
Yes, so why I'm saying that is that you say that there is an issue. There was an audit by the Bank of Ghana that said that 9 billion could clear that issue. When you took over in 2017, you said that given the circumstances and the monies appropriated, 25 billion rather than 9 billion. My point is that from the accounting background, if you take the assets like they have taken over Capital Bank, Heritage Bank, and they've given to other banks, the difference will be that indeed some 25 billion cedis have been misappropriated, for which reason you use the same either by way of liquidity support or whatever. But if we are being told that from the trial, given instances and given back and forth, the state today is admitting that with Capital Bank alone, the money misappropriated is 57.5 million, then we have to raise very serious questions.
All right. So what's your point? Should the state be pursuing Section 35 or they shouldn't?
Well, the state should be pursuing Section 35. But my question is that what was the policy direction of the state at the time of going to
that
court?
point is made. I just wanted your...
Is it the case that the state thought, well, let's start prosecution, let's save our faces. When we get to a point, then we come to Section 35. Because bear in mind, Heritage Bank, the founders are in court, the same for UT. Is it the case that this Section 35 will be available to these other people, or is only in the case of...
What do you think, as a lawyer, what do you think? Is available or is not?
I don't think, because in the NCA,
as a lawyer, in the NCA
trial, in the NCA trial, we were never offered that opportunity.
Who should offer it?
Both
No, it's not
parties.
both. It's not both. Particularly you, the one who is accused. I have used Section 35 in cases before. You, the one who is representing your client, must go to the Attorney General and say, look, the evidence I have seen so far, it doesn't look like things are good for my client, or whatever it is, my client is ready to pay and then pay compensation and be convicted but not go to
No,
jail.
the second
so if you didn't do that, don't blame somebody for doing it.
The second question I would want to ask in respect of this is that, is it the case that now A1 in the instant case is admitting to saying that although by documentary evidence, what I admit to is 57, but I plead guilty to the 90 million. Is that the case? Because you see,
good question. Let me go to the Attorney General then.
No, let me make my point. I'm saying that the state should not paint the impression that by going in accordance with Section 35, we are being saved money. Because from the report, when you look at the terms of settlement which has been presented to the court, we are told that A1 was willing to pay 30 million as at the dates they were already paid in court, 60 million to be paid in installment. The Deputy Attorney General's argument is that one of the reasons why they've had to go on this tangent is that in time past, when people are convicted, they don't get anything. And he copiously lamented about how it will be difficult to look for the properties of A1 in the instant case. My question is, this 60 million, which is supposed to be paid in installment, should the court go ahead and accept that, well, because you have both agreed, I accept the terms. If Ato Essien does not pay, does the state know where it can find its properties to offset the 60 million?
Maybe we should go to Section 35 too.
Yes,
what does it say?
I've seen that Section 35
Yes, what does it say? Because you do that and then you take some risk. Yeah, you are not convicted, but if you don't pay, you end up still going to jail.
Yes, but that's what I'm saying, that the state's argument is that one of the reasons they are going on this tangent is that they don't really want custodial sentence, or it is not in the interest of anybody. And so they will want to go on this tangent and then recover. My point is that if you cannot tell, or there are no specifics that because of the rationale behind the settlement, you bring property number A, B, C, D, or you give us some form of immovable guarantees that if you default to pay, then, I mean, this should be...
You've done the first guarantee, which is 30 million.
Yes, that has been paid. My concern is that...
You haven't, I don't know if you were a lawyer, you would even want your client to pay the money up front. But they have gotten that.
Yes, but
so you should applaud them for that.
It's no guarantee that they'll get the 60 million.
Yes, but that is also on the accused. If you don't pay, you go to jail.
Yes, but you see, the point is that...
So in that regard, the law is that it is not the Attorney General's job to now go around looking for you.
Exactly.
You have agreed that you pay 60 million and you pay it within a certain time.
Exactly.
Once you fail and neglect to pay, the law kicks in again. Yes. You are put to the court.
Just like when you are fined, if you are not able to pay your fine, you go to. But I'm saying that, so that rationale or that reason by the Attorney General is where I find a bit baffling, because if you are saying that the reason I'm going to this agreement is that I want to save money, now you have no guarantee that the 60 million will be saved, then why? That's the question. There has to be some guarantee for the people.
Thank you very much. But again, when you go to 35, there's no guarantee to be provided. Alfred,
there is no guarantee, let me end with you. Work of the
let me end with you on this. Do you appreciate what Beatrice is saying? That maybe she doesn't understand why you are saying what you're saying, because it does appear that if you get the 30, there's no guarantee that you get the 60 million. Is there not a way you can find and secure the fact that you can actually get the 60 million?
Thank you very much, Samson. I've listened to Beatrice. Yeah, that is the suggestion that she has put up. But let me make this intervention. Per what we have done, as Samson Lardi stated, now 30 million has been paid. If the judge accepts it and says we are going to go by the agreed sum, if the first accused person defaults, they automatically will go back to court for the court to sentence him to jail. So many, that's why we basically say double jeopardy. In that case, we've made some payment, but not just notwithstanding, you are going in. That's an advantage to the state.
All right.
In terms of providing guarantees, I think there's something I've not met before. Section 35 is not covered, but we are amenable to all suggestions. If it's possible, maybe in the future we'll look at it and see how that one also can be fixed.
What do you say to anybody who may suggest, and I am suggesting this to you, that why didn't you rather require that the settlement be done through the new law, the Criminal and Other Offences Procedure Amendment Act 2022, Act 1079. I'm talking about plea bargaining, where once the person agrees and the terms are filed in court, and on the basis of that, the judgment is rendered, it becomes final and cannot be appealed against. Why didn't you use that rather than 35, where issues can come up and they may take us through another, if you like, call it a Wyoming kind of process. Today, the Supreme Court, today, the High Court of Appeal, today, here and there. But this law, which is fresh, is also applicable and can achieve the same results, and the result cannot be appealed.
Yes, Samson, I think it's also a good suggestion. The Plea Bargaining Act is now in existence, but it is the offer of the accused person that will determine the reaction of the state. If the accused person or the first accused has chosen to go by the Plea Bargaining Act, who have followed him there, but the accused person chose to go by the Cause Act, Section 35. In terms of appealing against the current agreement that we have, if it goes through, I have my doubt if there's a process, unless you can maybe prove fraud. But apart from that one, you cannot appeal against it.
Okay.
It's not appealable, so you just have to stick to it. So something, that one is left to those of you in private practice, whether you want to go by Section 35 or you want to use the Plea Bargaining Act.
All right, so on the 13th, you are going back to the court to, the court says you should come and convince it that this amount is enough.
Yes, that's the ruling of the court. So we're back to the court on the 13th. In all this, I've said that the decision of the judge is supreme. You can agree on everything. Maybe the judge says he is not satisfied. The thing falls, and we have to go back and then have the judgment delivered. So we go to court on the 13th. If the judge is satisfied with the arrangement, we'll move along. If the judge is not satisfied, we will drop it and respectfully ask the court to proceed in accordance with law. Right.
Ghanaians are interested in all the other cases because, as we speak, I didn't cause any trouble yet. Once I'm accessing banking services, I am paying for this bank collapse issues when I didn't cause anything. So what are you doing to the other cases?
In fact, the state has done a lot of investigations into the collapsed banks, savings and loans, and microfinance institutions. And the dockets, if we were to come to our ministry, you look at how bulky the dockets are. So we are taking them one after the other. I think about a month ago, is it less than a month, Beige Capital were in court. So it's maybe an announcement to those who manage those institutions. If they think that it is over, it is not over.
All right.
After when their time comes, we'll get to them.
Yeah, your reference to Beige Capital reminds me. Can you give me a minute on this? He had referred to another case. I think it was done in his own court too, where you did this kind of arrangement. What has become of that?
No, Beige Capital, I think that we've not gotten to that stage, unless maybe it's another matter. We were in court last month for the first time. The court granted him bail. I understand he's not able to meet the bail conditions. He's still in custody. I'll be going back to court this next week. I think next week or something, yeah.
I'm talking about this matter where I think the debt amount was about 40 and you were getting 70 out of it or something, and you reach a similar agreement. I'm forgetting the specific name. Is
it a venture capital?
Exactly,
one?
Exactly.
All right, yes. The venture capital one is somewhere in 2019. There was a similar arrangement for him to refund. That's about 13 point something million. Was it 13? I don't have it. I think 13 or 14 million.
Okay.
But after the state had agreed with the accused person and the state had gone to court with them, the judge in his wisdom said he was not comfortable with the arrangement, but rather the judge gave another suggestion that Mr. Duku has some property, and that those property, the state should go ahead and auction those property to defray that amount. So those properties, currently as we speak, the auctioneers are working on it. They've taken every step they're supposed to take. And very soon, I think we'll be able to get the money from there. That one, the state never proposed that we're going to take the property to auction. But the judge, in his ruling, said that was what he was going to do. And he did it.
Okay. All right. Thank you very much. I'll have Mr. Otu give us a brief commentary on this, and then we take a break. Section 35, when I said you should look at 35.2, I meant 35.7. It says, where a person convicted under this section defaults in the payment of any money required of the person under this section, or fails to fulfill any condition imposed by the court under subsection 6, any amount outstanding shall become due and payable, and upon failure to make the payment, the court shall proceed to pass a custodial sentence on the accused. And then I was also referring to the Plea Bargaining Act, which has now been done. You know, apart from this section, we passed the Office of Special Prosecutor Act, and we also put plea bargaining there. And then we passed the Narcotics Commission Act. We also put plea bargaining there. And then we felt that we needed one law, you know, to take care of all of that. So we have a new law now that takes care of all of this. So if you have a case from start until judgment has been rendered, you are entitled and are allowed to ask that you want to pay and make restitution or reparation and get a conviction but not go to jail. So you make admission of your guilt. And this one, a part of the section which I was referring to, Alfred Tuyeboa, says that where a court convicts and sentences an accused person in accordance with the plea agreement, the conviction and the sentence shall be final, and an appeal shall not lie against the judgment of the courts. I thought that would have been a better way. Ms. Otu, what will be your brief commentary on this? Let's leave the lawyers and go to generally what you feel about all of this before we come to you and the government, as in Labour.
Thank you, Samson. It will be brief. I'm not a lawyer, and I haven't followed the case that much, but I've been educated a lot listening to all of you. Thank you for that. The question I ask is, there are many people in jail for having stolen 10 Ghana cedis.
Exactly.
1 Ghana cedis. And it makes me confused. Maybe I need to read more and I need to listen to all of you more. But it really makes me confused. Thank you.
Thank you very much, Dr. Kwabena Nyako Otu, Chief Economist and Director, Labour Research and Policy Institute, Trades Union Congress. Earlier, you heard Beatrice Annan, who is here in the studio. He's member Legal and Communications Team, National Democratic Congress. Kofi Bentel is lawyer and Senior Vice President, Imani Africa. We're taking a break, but Kofi wants to say something in a minute. Kofi, do that and let's go on a break.
Very well, Samson, you said a bit of it. First thing we need to get right. Look, some of us, you and I, if we were not sure about the process, we would say it. We are saying the process is good. Number two, very important thing is this. In the numbers, what is admitted is just about 26 million, but the state got 90 million. That includes interest and other things. We need to know that. That's also another fact. Then the last one you said, which is very important, is this. The enforcement, what if it doesn't pay? In other arrangements, when you get the person say, I will pay, and therefore they go. If they don't pay, you have to go into execution, etc., and you may not get the money. In this case, 35 and the other laws related are better because, one, if they don't pay, they will go to jail. All right? Yeah. And also, when they come under this kind of agreement, they don't go and appeal. So you save money, you save stress, you save all kinds of things. All right? So this is far better than what we've had. And I'm adding to it that what has been gotten under this, 26 million having been admitted, the state has managed to get them to commit to pay 90 million. All right. So again, we don't have to go into the details of the figures. The lawyers will do that, but these things must be said.
But Dr. Otu raises an issue. When I wrote about the Plea Bargaining Act and the Community Sentencing Act bill, which doesn't really get passed, so that people who steal plantain and things can also have the opportunity, you know, of instead of going to jail, to do some small service and, you know, get away, so to speak. That is not receiving the needed attention as we expect. But this one has received quick attention. Special Prosecutor Act We have provided there that you can plead and then pay as compensation and go. Narcotics Control Commission Act, the one we did recently, we are provided there. And we know that these are, quote unquote, your big thieves. What happens to the ordinary person?
On these small claims and these non-custodial sentences, because that's the bulk of the matter. And we need to really focus on them. So there's a lot of work being done there, but people should be clear about this. There's been a lot of thinking across the world. Even murderers are allowed to do plea bargaining because there's a greater good to that. It may not look okay in the beginning. It may not rub you right at the beginning, but sometimes you have to trust the people in charge. I doubt if any of the people complaining now, if they were put in the facts of this matter and given the details at this stand, I doubt if they'll do better than the Aegis Department has.
Okay, thank you very much. But because you mentioned murder, let me state that in our law, if you commit treason or high treason, you can plea bargain. If you commit high crime or accused of high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and an offense relating to public elections, you can't plea bargain. We'll be right back.